A Supreme Court ruling that may do two things. As a consumer, it may make it easier for you to sue a business if you are injured on that business's property, for instance, in a slip and fall accident. On the other side of it, it opens up more business owners and employers to litigation potentially for things that they were once protected from if the hazard in question was open and obvious. Let's deconstruct this ruling from the Supreme Court with Tim Holland, attorney with Michigan Auto Law. Tim, good morning.
Hey guys, good morning.
Kind of break down. Did I set it up properly there? We had this concept of open and obvious. How did that previously protect businesses and also kind of blockade consumers who were injured Americans from the courthouse?
Yeah, Guy, I think that's pretty close. So in 2001, we had a decision that came out called Lugo versus Ameritech, and that set up this idea that really placed responsibility on the people that would be on the private property, and they created this doctrine called open and obvious. And what it says is that if a hazard that causes someone to fall is readily observable upon casual inspection, it was the duty of the person walking to avoid it rather than the duty of the premises owner to make it safe. That now has been changed, and we think it's been changed for the better here. The new decision, which I would encourage all your listeners to go check out, which is the El Said versus F&E Oil and Pinsky versus Kroger of Michigan, really it eliminates the open and obvious doctrine. And the big advantage here for the public is that it encourages property owners to make their property safe, to help keep the public at large safe. And the other thing it does is it takes the decision-making power here as to who is at fault for a slip and fall really away from judges and puts the responsibility with juries to kind of look at any given situation where someone falls and is injured and then make a decision as to, who was responsible for that fall and that injury. So that's kind of the change there. That's what we have.
So Tim, let's just give a scenario. I walk into a store and they just mopped the floor, and they may have one of those yellow pieces on the floor to say, wet floor or whatever like that. And I walk in and I slip on the floor, then I'm at fault now. That it's not the business that's at fault, or how does that work?
Well, the way it's going to work is the jury is going to decide that. The jury is going to decide who is at fault more for that situation. So previously, under the Lugo decision, a judge would simply decide that. The judge would look at the situation and say, hey, that sign was there, open and obvious. The premises owner didn't have a duty. What the El Said decision does is it says, no, we're gonna take that, we're gonna place it in the hands of the jury to then decide who was more at fault for the fall. The business owner for example, having an extremely dangerous or hazardous condition during open hours, even though there was a warning. Are they more at fault, or is the person that was walking that walked in that area and slipped and fell, are they more at fault? So the decision, it takes the question away from judges and puts it in the hand of juries to determine on a percentage basis who is more at fault for that injury.
Right, but in so doing, what the criticism is going to be, Tim, that this is going to open up businesses to a spate of lawsuits that maybe reasonable humans would say we as consumers have an obligation to protect ourselves, and that it will significantly raise the cost of doing business because liability rates will go up for those businesses because of the enhanced probability of a lawsuit.
Well, it certainly maintains the defenses that the business had. I mean, it's not taking away responsibility of people walking. It just says it's going to be decided at a different level.
Okay.
So previously, the judge would simply decide it, where now a jury will have to look at every situation and decide who is more at fault. The real point here is that this should raise safety. And a big part of our practice and a big reason that we're engaged in this area of practice is to really encourage safety and to make the Detroit area safer when it comes to people being out and about, people walking on businesses and private property. And so this decision, it does preserve the rights of businesses to say, like in Lace's example, hey, there was a sign there. They should have walked there. Should have been more careful. That defense is still preserved under this decision.
Okay.
It's just going to be decided at a different level.
Or putting it in a different scenario, because I think Lloyd's scenario was a good one. If it's an icy morning, but I have thrown salt out there, I have taken measures to try to mitigate that and to make my property safer. Does that indemnify me?
Yeah. So again, what'll happen there is that you'll certainly take pictures of the fact that you salted. That'll be your testimony, in the case or in the insurance claim. That'll be your version of events. You'll have pictures of the fact that you salted and they still fell. And again, that'll be considered on a percentage fault basis.
But again, Tim, in all due respect, I still have to go to court to prove that, and I'm going to under substantial cost before I was protected from something like that, because the law already said, look, if you've done your due diligence and it was open and obvious, you're protected, right? So there's going to be increased cost no matter whether it's a good defense or not.
Well, that is a balance that we have to do here in Michigan versus the safety concern, because what the law was previously is that you really didn't have to do much in terms of safety, and so there is going to be a little bit of a cost benefit analysis that's ultimately going to happen after this El Said decision, which is going to be, yes, there could be some additional costs associated here, but did this encourage people to make it safer for people to walk? Were people ultimately safer? Were people getting hurt less? Particularly like in and around Metro.
Sure.
Were people getting hurt less as a result of the increased safety requirement here? So again, you will have potentially more claims, but on the back end, we hope. And again, this is a big part of why we practice is we hope people will be much, much safer after the decision, even with the potentially increased costs.
And before, Tim, the businesses were basically protected. Are some businesses saying, well, I'd rather have a jury look at this than just have a judge say X, Y, Z?
Yeah, they are confident in their safety measures. A lot of businesses who are confident in their safety measures, they look forward to proving their day in court. Because they've documented, they have policies and procedures, which is a big thing that we look at in cases are, what are the policies and procedures? Were those followed here? Were actions taken? And so you end up with, potential defendants who did the right thing here. They still get to have their day in court and say, hey, we did everything right here. This should be thrown out, or we should still prevail. Where on the flip side, where you had a lot of, businesses in Metro that it's just anything goes. We've got this defense of open and obvious, and it doesn't end up being any safer for the customer or the consumer.
Right. With open and obvious, though, that can be so subjective that you could see egregious behavior on the part of a property owner, but you still couldn't sue them for that.
And that's the flip side of the safety concern. You could have you could be at Kroger, there could be a pit in the middle of the store. If that was open and obvious under the Lugo decision, people could fall in the pit, have no recourse against the store. Where now under the El Said decision, a jury will determine on a percentage fault basis who was more at fault for having such a dangerous condition. And again, it really comes down to safety. I mean, certainly, what we're looking at as part of this decision, and what we hope happens is that there's no increase in litigation or other costs, because the business owners and the corporations will increase their safety as a result of seeing this decision, and hopefully claims go down, people get hurt less, and safety's up all across Detroit.
Now that they don't have this big shield. And I also would imagine that you will see businesses document their efforts to make their property safer as well, perhaps with surveillance cameras, things like that, to show the due diligence there, so that they have the means to prove it in court when they get there. Tim Holland, thanks very much for breaking it down for us. We appreciate it. But more protection certainly for consumers, more ability to go to court if you have been injured, and some property implications and legal implications for business owners as well. Thanks for your time.
It was a real pleasure. Thanks, guys.
All right. Pleasure for us too, Tim. Thanks very much.